Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Hello, everyone. Good evening, and thanks for joining us for another medical legal webinar. I'm your host, Alan Tay, and today we are going to have an interesting talk, which is very topical because of recent court judgments. And the topic of the webinar is on non-delegable duty, and the speaker is Ms. Shamini Navaratnam. Before we stream the video, which was pre-recorded, I'll just go through some housekeeping slides. Q&A, we will try to get onto Slido. Earlier in the evening, I had some connection problems. I just couldn't get into Slido. So if you have problems connecting, you can use the YouTube chat, okay? And we will highlight your questions to Ms. Shamini when she joins us live after the stream recording. Please do like and subscribe. Feel free to share the video. This webinar is free for everyone to watch. And if you think your colleagues will benefit from what has been presented, please feel free to forward to them. Okay, we appreciate if you can subscribe to the channel so that it will help us grow. Claiming CBT points, I think the dentist, you would have been provided with a link to pre-register for the event. I created a little shortcut so it's easier to get to the long link. It's docs.my/dentist0424. For the medical doctors, I'll display the attendance link at the end of the talk so you can register and get your points at the end of it. All right, so without further ado, I'm going to start the live stream, and I hope all goes well because the internet connection was a bit wonky. So here goes.
Good evening, everyone. And today I'm going to speak about a topic which has been very hot in the news, and all medical professionals and hospitals have been talking about it. And in law, the concept is known as non-delegable duty. There has been a recent case in the federal court, and I believe this has generated a lot of interest in respect of this concept of non-delegable duty. All right, before we go into non-delegable duty, I thought it's best I introduce medical malpractice actions so that all of us can understand a bit more about non-delegable duty. So whenever we have a medical malpractice action, we will have the plaintiff, or if the plaintiff is incapacitated in the sense that he's brain damaged or unable to bring an action, he will have a litigation representative which will be a member of his family who will bring an action on behalf of the patient. Or, of course, if the patient is deceased, again, the person who's clothed with authority, the personal representative of the patient, will bring an action in court. So this is the plaintiff. The plaintiff is normally the patient or the patient's family members will be the party who is suing and bringing the medical malpractice action. Now, who are they suing? The parties they sue are called defendants in court. And who do they normally sue? If there's an adverse event, in the event they have been going to be treated by a consultant or a doctor, they will definitely sue the treating doctor or doctors. If there are multiple doctors who have treated the patient from the time he entered the hospital, he will make all those doctors as co-defendants, all right? And then in many cases, because the patient does not know or feels that there is some involvement in the hospital, they will also name the hospital as a defendant. All right, so of course, there's either public hospitals or private hospitals. For the purpose of this talk, I will limit it to private hospitals. All right, and what is the cause of action against the consultants and the hospital? The cause of action, of course, is usually threefold. It is usually, firstly, they will say breach of contract, because there is a contract between the doctor and the patient. There is a contract between the hospital and the patient. So they will sue for breach of contract. The second cause of action that they will sue is usually in respect of negligence. Negligence, as you know, means that doctors and hospitals owe a duty of care to patients. And if there's an adverse event, the patient will always allege that the doctors and the hospitals have breached the duty of care to the patient. The negligence suit is the fact that the breach must have caused the damage, right? Whatever injury or losses that the patient has suffered must be due to the negligent act of the doctors or the hospital. All right, and just before I move on, whenever a hospital is sued, it usually also includes what is called a system failure. There's something wrong in the system, either communication or equipment. So it could be called a system failure. The second reason why hospitals are sued is in respect of the nursing care or maybe pharmacy mistakes. They can also be sued for that. And the third one is lack of facilities. And the third cause of action is they talk about breach of statutory duty. Breach of statutory duty is the fact that there are certain acts and statutes in Malaysia, and for the purpose of medical negligence and the relevant act in force in this country is obviously the Private Healthcare Facilities and Services Act 1998 and the regulations made under that. So that is the relevant act which usually is used. Of course, if there is any allegation of breach of confidentiality or personal data, then it's the Personal Data Protection Act. Could be another statute which they bring the action against the doctors and the hospital. Okay, what is the general procedure? As I said before, I talk about non-delegable duty. I think it's important that we understand what the procedure is when a suit is filed. All right, so what happens is usually all the defendants, the court will give the defendants time for the lawyers to file what is known as statement of defense. And that would be your defense to the action filed by the patient. All right. And that is usually, you will say that all reasonable care has been taken. You've complied with the standard practice of the profession. All right. So that's the usual defense. that doctors will take. As far as hospitals are concerned, they will say that their systems are safe, and they will say they have employed competent healthcare professionals to take care of the patient. And they will also say they've complied with the standard expected of a reasonable private hospital in Malaysia. That's the usual defenses of doctors and hospitals. What happens next? Very often, in the present state of affairs between private hospitals and consultants, there are usually agreements entered into between the hospital and the consultant, where the consultants are known, agree to be independent contractors, and there's usually a clause there in a contract between the consultant and the hospital that they agree to indemnify the hospital should any action be brought by the patient and the loss of damage is caused by any negligent act on behalf of the doctor. All right. So what happens after these what is called pleadings are closed? These are the pleadings. When pleadings are closed, what happens is the matter goes before the registrar or judge to have pre-trial case management directions. This is just administrative between the court and the parties and the lawyers. But what will happen is that we will have to file documents known as agreed facts, agreed issues to be tried, and then the agreed bundle of documents are all the documents which include the medical records of the patient, together with perhaps the consultant agreement, and all these documents will have to be filed. And then in every medical negligence case, usually when doctors and hospitals defend the case, they will always engage experts. And the procedure in court is the experts have to, when they produce their expert report, they can't just file it in a bundle. They have to make a sworn statement called an expert affidavit, where they annex their curriculum vitae and their expert report. And finally, the last thing to be done by the parties, usually a month before the trial, is that they file witness statements, which is basically their story of what their involvement with the patient. All right, what happens next? Now is the exciting part. It is the trial. And in the trial, what happens is that the procedure is that the plaintiff will have to give evidence, which is usually the patient. And then the patient is usually also, they will have to get what is supporting evidence. So, of course, sometimes they don't have any documents to support them. So they will call their family members to support what evidence that they give, which they feel is the breach of duty by the hospital or the consultants. Then, of course, the plaintiff always will engage an expert who has examined all the documents, and he will say there has been non-compliance with the standard of care expected of the consultant. And that's what is usually done. And then, of course, when the plaintiff sues, they always sue for a loss, financial loss. The financial loss has to be proved. So assuming that they needed to renovate the house, then they will have to call the contractor or whichever witness to prove their loss, because the losses have to be proved strictly, which means the plaintiff just can't give evidence that they spent so much money. The proper way is for them to call witnesses to prove their loss. That is, of course, the quantum aspect of the claim. All right. Now what happens when the defense case is called? So when defense case is called, it usually depends on the order that the plaintiff has named the defendants. If the doctor or consultant has been named as the first defendant, then the doctor will give evidence. The doctor's expert, again, after he has filed his expert affidavit, will give evidence. Then the hospital representatives will give evidence, and any other relevant witness. Sometimes, of course, when we're talking about care of the patient, it's important that we call a nurse to corroborate and to defend the management of the patient. All right. And then what happens in the notice of indemnity and contribution? This is the parallel actions the patients claim, wherein the hospital is claiming an indemnity from the doctor. So what happens is, at the trial, all that is necessary is usually for the hospital's witness, hospital representative, to introduce the consultant's agreement, and that will be sufficient. All right, now to talk about non-delegable duty. Non-delegable duty is a concept which arose, I think, in the late 1990s. The first case I'm aware of is the case of Liao Mui Mui, which is a case where a locum doctor did a DNC procedure in a clinic, and the clinic owner was sued. The locum doctor was not named as a defendant, but in that case, that's the first time I'm aware in Malaysia that the court said that by employing the locum doctor, the clinic owner had assumed a non-delegable duty. So if there was injury to the plaintiff, in this case, the plaintiff suffered injuries to her intestines after the DNC procedure, the court held the clinic owner liable. And one of the grounds that they found the clinic owner liable was the ground of non-delegable duty. It means that even though you are not the party which created the event or damage to the patient, if it is someone who is your agent, like a locum doctor is employed by the clinic, then the clinic will assume liability to the patient. All right. Now, following on from this case of Liao Mui Mui, there was another important case which was involved the injury to the eye, which was, of course, the Tun Hussein On case, and two doctors were also sued together with the Tun Hussein, with the hospital, with the private hospital. One, of course, was the ophthalmologist, and one was the anesthesiologist. And in that case, again, what the court did was, even though they found the hospital, they found Tun Hussein On Hospital guilty under this doctrine of non-delegable duty. All right, because in that case, the court found that there was some lack of care on the part of the doctors treating the patient, but they did not just leave it as liability against the doctors, because of course the doctors were practicing at Tun Hussein Eye Hospital. So that is another case wherein a court held the hospital liable on the grounds of non-delegable duty. Of course, everyone is very familiar with this case because it was the first time that the federal court actually awarded aggravated damages. All right. So I think the aggravated damages was the part of this case which was highly publicized. But apart from the aggravated damages part, it was very important because the hospital was found liable on this other ground of non-delegable duty. All right, this case went up all the way to the federal court. All right, what happened after this case? Okay, so this was the big case, the Hussein On case. After the Hussein On case, the next big federal court case, which the federal court decided, was in 2018, and this is the famous case of Dr. Kok Chung Seng and a private hospital against Su Cheng Lin. All right, so what happened in that case was interesting because the court seemed to put um, a limit to the circumstances which a private hospital could be guilty of negligence under the doctrine of non-delegable duty. They seem to examine the fact situation of each patient. Like in this case, the consultant saw the patient in his own clinic, which was not in the hospital. And then when the patient came to the hospital where the patient suffered injury, um, there was a contract in place between the hospital and the doctor concerned, where the consultant was an independent contractor. All right. So on the facts of this case, the, the federal court then limited the application of non-delegable duty to suggest that not in all circumstances would a hospital be liable in the event the patient personally chose the consultant concerned. And of course, would be supported by the fact that the patient met with the consultant outside the hospital before coming to the hospital to do whatever procedure and suffering injury and damage. All right. And in this case, as I said, it was found by the court that the consultant was an independent contractor. And this case is very important because they applied the dicta in an English case called Woodland versus Essex County Council. And they said that in that English case, there were 5 features to be fulfilled before non-delegable duty could apply. And they added another ground apart from that in Woodland to say additional tests whether it was reasonable to impose non-delegable duty and all the circumstances of the case. All right, and that case was very important, not just from the point of view that the hospital was found not liable on the grounds of non-delegable duty, but what happened was in that case, the hospital can also claim indemnity from the consultant due to the independent contractor clause in the contract between the hospital and the consultant. Okay, and following on with the Dr. Koch case, there were many cases which went to the High Court and Court of Appeal, wherein the hospital was exonerated from liability on the basis that the doctrine of non-delegable duty did not apply. All right, so that brings us to what has happened this year. All right, so this year there has been a case known as Xiao Cheng Yi versus Columbia Asia, and this case went up to the federal court, and the federal court delivered its decision on the 23rd of February. Okay, let's talk about this case, the background of this case. All right, and the background of this case is that the patient sued because the patient was brain damaged, all right, and had a lot of physical and mental disabilities, sued by a litigation representative in an anesthetic incident, all right. The parties who were sued was the ENT surgeon, the anesthesiologist, and the private hospital. There were 3 defendants who were sued. So what happened is this case was determined in the High Court, all right, wherein the claim was dismissed against the ENT surgeon and the private hospital, but the claim was allowed against the anesthesiologist. The anesthesiologist in this case filed an expert report which was not supportive of a defense, and the expert was not called to testify. Now, in the event you present evidence to court and you do not call the witness to court to test that evidence by cross-examination, there is a concept in law known as adverse inference. This purely means that the court is going to believe that the evidence that you give will not support the case of the defendant. And that's exactly what happened here, because the expert was not called to give evidence, but the report was there, which was not supportive. The court held the anesthesiologist liable. All right, so what happened next? So the plaintiff appealed against the dismissal against the hospital, the ENT surgeon, and the anesthesiologist appealed against the liability to the Court of Appeal. The anesthesiologist's appeal was dismissed by the Court of Appeal. The Court of Appeal similarly dismissed the claim against the ENT surgeon and the hospital. Unfortunately, there are no grounds of judgment available, so we are unable to understand what was the reasoning why they came to this decision in the Court of Appeal. But do you think that the patient was happy that they managed to get judgment against one party? And I believe what happened here was that the quantum was very high. The quantum awarded by the High Court, which was not disturbed by the Court of Appeal, and what happened was the insurance was acting, or the doctor's insurance coverage was not sufficient to satisfy the total amount of damages awarded to the plaintiff. All right. And again, the plaintiff was not happy. They felt that they should receive more money than what was awarded by the High Court. But in any event, before you can appeal from the Court of Appeal to the Federal Court, what needs to happen in court is it's not an automatic right. Only questions of law which have not been decided previously, or the law has developed and you need the court to consider the new developments, you apply for something known as leave to appeal. And in this case, leave to appeal were granted on 7 questions, all right? The questions are all set out in detail here. But basically what the questions suggest is whether or not the decision in Dr. Kok Chung Seng, which I said was the law previously, where it was not in all situations that the plaintiff or patient would succeed against a hospital under the doctrine of non-delegable duty. What the patient said to the federal court is that the law has changed in the United Kingdom, and therefore the law as expounded in Dr. Kok Chung Seng needs to be reviewed, particularly in the light of the extent and the test for non-delegable duty. All right. And the other interesting thing about the leave to appeal in this case, in the Columbia Asia case, is that prior to this Columbia Asia case, usually the hospital will only be held liable if negligence is proved against the hospital directly or against a doctor who is practicing in the hospital. But what this Columbia Asia has now sought to do is to extend the grounds where a hospital, a private hospital, may be held liable to a patient by asking whether there is a statutory duty of care. This is question number 5. Whether there is a statutory duty of care independent of a duty in negligence of contract owed by the owner and manager of a private hospital under the Private Healthcare Facility and Services Act 1998 and regulations thereunder. All right, so this now is clearly asking the court to decide whether there is an independent duty of care other than contract and negligence. All right, the other question which is important, which is decided by, had to be decided by the federal court, is question number 4. Whether the owner or manager as a provider of healthcare may escape liability for breach of such duty of care committed by a doctor because the doctor is an independent contractor which has been engaged to practice in the hospital. All right. So that was why I emphasized on the notice of indemnity and contribution, because this question is related to whether or not the hospital can say they are not liable because there is the independent contractor and clause there wherein the doctor has to indemnify the hospital because of the contract between the consultant and the hospital. Right? Okay. Then, of course, question 7 is a matter of what is the test for non-delegable duty because of the developments in the United Kingdom, right? So they then wanted the court to decide whether or not this additional test of just, fair and reasonable should be a ground in which the court has to consider before determining whether there is a non-delegable duty. Right? And of course, there was one further question, which I am not going to talk about today, on whether or not the earnings of the patient as a director in a private company, whether that should be taken into account in awarding damages to the patient. Okay, so that I will not be talking about today because that relates to quantum. All right, today I'm concentrating on the aspect of non-delegable duty. All right, what is the practical effect of the federal court decision? So what has happened in this case is that the court has given a very broad and sweeping statement wherein the patients can expect to be compensated by not just the doctor, but by a private hospital whenever a private hospital accepts a patient onto its premises. All right, so long as the patient step foots in the premises, the private hospital will not be able to escape liability in the event an adverse event takes place to a patient. But of course, the patient has to prove the adverse event or the injury suffered and the damage suffered was due to negligence on either the part of the doctor or the part of the hospital. All right? So this is what this case has now suggested. And apart from that, it will be easier for the patient to establish liability against the private hospital, because apart from the duty in contract or the negligence, where negligence has to be proved against the doctor or hospital, now in the event they show there's a breach of regulations under the Private Healthcare and Facilities Act or regulations, then the hospital will also be liable under the doctrine of non-delegable duty. And now I'd like to talk about how the judgment sum will be divided to be paid between the doctor and hospital. From the federal court decision, it appears to be that the private hospital is now 100% liable to a patient for the entire judgment sum. apart from, even though the injury took place due to negligence of a medical practitioner or consultant in the hospital, now under the doctrine of non-delegable duty, they are jointly and severally liable together with the medical practitioner. You see, but there is a conflict on how this is to be interpreted in view of the fact in this particular case, the question of law talked about the amount which was not covered by the doctor's insurance. So it's basically the deficit or shortfall. Is the private hospital obliged to pay that shortfall so that the patient recovers the full judgment sum? However, a reading of the federal court decision doesn't appear to make that distinction. So we do not know how the courts are going to apply it for future cases. And of course, it doesn't make sense because at this point in time, I think it's compulsory for every doctor to take out insurance. So if the doctors have insurance and the hospital has insurance, it does not make sense in the event the negligent act took place on the part of the medical practitioner for the medical practitioner's insurers not to pay any amount under the judgments. So we do not know how the courts are going to apply this. And the next important development is that in this new case of Columbia Asia, the federal court stated that the private hospital cannot avoid liability by purely stating that there's an independent contractor clause between the doctor and the hospital when a negligent act takes place at the hospital premises, as it used to do. All right? It now, the federal court has clearly said that the hospital cannot shelter behind the independent contractor clause. Now, the final part of the judgment, which is very interesting, is the part where the federal court has now made a pronouncement on the notice of indemnity and contribution, and to state that the hospital cannot rely on notice of contribution and indemnity proceedings brought against the medical practitioner to claim an indemnity for whatever sums they've paid out. Again, this is what we call an obiter statement, because I do not think that this notice of indemnity and contribution was part of the questions of law, and therefore we are unable to predict how the courts are going to interpret it. There is a statement in passing in the federal court judgment that the hospital is not entitled to take out notice of indemnity and contribution proceedings against the doctor to claim an indemnity of any amount they paid out under the independent contractor and the contract between themselves and the doctors. But as I've said earlier, this doesn't appear to be one of the questions posed to the federal court. And so we do not know how much of this part of the majority judgment of the federal court is going to be applied by the courts in the future. All right. And the final part I want to talk about is the fact of impact on private hospitals. So I believe there is going to be a great impact on private hospitals as to the increase in litigation, anticipated litigation, and not just anticipated litigation. It appears to be, it is now going to be easier in the event a negligent act is proven against any of the doctors at the hospital premises. The hospital will be liable under the doctrine of non-delegable duty. All right, so therefore, previously it's only in cases where the hospitals directly employed the doctors, or in government hospitals or in university hospitals, where the doctors were employed under contracts of employment, there's a different concept of law called vicarious liability. In those cases, of course, the government hospitals, university hospitals, or private hospitals would be liable under the doctrine of vicarious liability to the patient. But now it appears to be that we don't even have to have a contract of employment, so long as you practice, a medical practitioner practices at a private hospital, the private hospital will still be 100% liable to the patient. All right, and however, it's of course limited to the fact that in the federal court decision, they make it very clear negligence will still have to be proved on the usual basis before liability will attach to the doctor or to the hospital. All right, it's, as I said, it's just that it has now become wider, because the patient can either prove breach of contract, negligence, or they can even plead and prove breach of any regulation under the Private Healthcare and Facilities and Services Act. So it is going to have a great impact on the private hospitals, their insurance arrangements, which are presently in force, and how is it going to affect future insurance agreements. All right, and then again, we do not know whether the hospitals will be able to extend to which the hospitals can claim indemnity and contribution from the consultants who practice at the hospital. But as I believe the situation is not clear, I believe that for the time being, the notice of indemnity and contribution proceedings will still continue to take place whenever a claim is brought against the hospital and a medical practitioner. Thank you very much.
Well, thank you, Ms. Shamini, for the excellent talk. And Ms. Shamini is now here, and I'm going to invite her to the stage. So, hi and welcome, Shamini. Thank you for the great talk. And now it's time for Q&A. So we've got the Slido link up there. If you manage to reach the Slido, um, let's see if there are. I'm having problems connecting to Slido my end, so excuse me if I can't share the Slido link. But let's get the YouTube comment and questions. There's one from John Doe. In what ways does the scope of non-delegable duty differ between public and private healthcare institutions? Are there unique challenges or responsibilities faced by private hospitals under this doctrine?
Can I answer that question?
Yeah, sure. Go ahead.
In the first place, for public hospitals, there's no question of non-delegable duty, because as I mentioned in my talk, in public hospitals, all the doctors are employed as employees of the public hospital. So in that case, in law, the hospital assumes liability under the doctrine of vicarious liability. So there will not be a situation of non-delegable duty which arises. However, for private healthcare institutions, a lot of the consultants and doctors have a separate agreement with the private hospital, for example, like a consultant's agreement. And in those agreements, as I mentioned, usually there would be a clause, independent contractor clause, and there would also be a clause in those agreements saying that in the event a claim is brought, then the hospital and the hospital has to pay out any money. They can claim an indemnity from the doctor. That would usually be in the consultant's agreement. And what has happened is when patients brought cases to court previously, in some cases where the doctors were held negligent, the hospitals stated, or the court found that the hospitals did not have to pay out because there was no non-delegable duty. This usually occurred when the patient chose the consultant, saw the consultant in a clinic outside the hospital, and then came later to the hospital to do a procedure, and an adverse event took place. In those cases, the court made a distinction and said the hospital was not liable because the patient chose the doctor herself. All right, but now after this federal court case, it appears to be it will not make a difference. It doesn't matter if the patient chose the doctor, so long as the negligent act took place within the hospital premises, then the hospital would still be liable. And this is what's going to be the big challenge and responsibility to the private hospital, because you find that it's very onerous, because you can never predict when there's going to be a negligent act or adverse event taking place in the hospital, and you don't know whether the patient is going to say any of the regulations of the Private Healthcare and Facilities Act have been breached. And in that case, the patient could arguably succeed in their claim against a private hospital. Now the net is very much wider, and it's more difficult for the private hospitals to avoid liability under the doctrine of non-delegable duty. But as I said, a lot of the questions of law were not directly answered by the federal court, and there is a dissenting judgment. So I hope that there will be another federal court case which will shed will be more specific to answer the various fact situations which will arise. We are unable to say for certain now how the courts are going to apply this judgment. Thank you.
Thank you, Shamini. There's another question. So, what are the circumstances in which the private hospital will be held liable for the actions of third-party vendors, for example, cleaning companies, maintenance contractors, under the concept of non-delegable duty?
I believe that in these third-party vendors, it is not so much the concept of non-delegable duty. It will be a case of the hospital not having a safe system. You see, if an act takes place which is the fault of a third party vendor, usually it would mean the hospital will be liable in straight negligence. And the way that the patients plead the case against the hospital is that the hospital is not having a safe system being practiced in the hospital. It's not under the concept of non-delegable duty.
So, related to that, can you discuss the implications of non-delegable duty on patient safety protocols within private hospitals, and how this doctrine influences the standards of care that hospitals are expected to maintain?
I think it's going to be very, very important for the hospitals to review their safety protocols and the SOPs. From my experience, I think even now the protocols and SOPs are in place, but I think the difficulty is consistently maintaining the implementation of these safety protocols. Because I believe in a private hospital setting, there are so many different parties involved in the care of the patient. It may not specifically be the doctors, it may not be the nurses, but the whole for various different type of problems that the patient faces. There are different SOPs in place, and the hospitals must try and improve on the SOPs presently in the hospital. They must review them and maybe find a way how it can be implemented. There must be a check. And I think this comes down to training, really, because I believe there must be more education within the healthcare professionals handling the patient. Because as I said, the standard of care is still the same. It's a reasonable standard of care based on the current standards of practice by the relevant, medical professional. The standard of care has not changed by virtue of this non-delegable duty. But what has happened, it becomes easier for the patient to prove negligence. Because now, as I said, previously it was dependent on usually the experts coming on behalf of the patient, and then the experts for the consultant or doctor, and for the court to come to a decision whether they complied with acceptable practice of the profession. But now, after the case of Columbia Asia, it appears to be now wider, that they can actually use the regulations and the Private Healthcare Act, and to say if you have breached any of those regulations or duties, you can prove negligence.
There are some questions appearing in Slido now, but can we take this one from Patrick Tan in YouTube? Is there any way the private hospital can protect itself from non-delegable duty of care?
I think the only way to protect yourself arises from the last question that I told you, is that it has to be very strict control and education of all the healthcare professionals, so that they carry out their duties and follow the SOPs in place, which are acceptable for patient safety.
You know, even the SOPs are in place, but humans being humans, it sometimes make mistakes. If the SOP is not followed by the independent contractor, is the hospital still liable or under the non-delegable duty? I'm not clear. Or has it to be an employee of the hospital, like a nurse or technician um, or a pharmacist or something?
See, that's why now it's wider. Previously, you're right, it had to be under the vicarious liability. You had to prove negligence against the pharmacist or the nurse or someone employed by the hospital. But now, after this Columbia Asia case, so long as any of the doctors, whether it be someone employed under a contract of employment, like some medical officers or other doctors, but even the consultants who have a separate consultants agreement, if something goes wrong in their management of the patient, the private hospital would still be liable under this doctrine of non-delegable duty.
No matter whether it's an independent contractor or employee. Is that what you're saying?
Yes, to me now, there is no difference, very little difference, maybe I should say very little difference between vicarious liability, which would be liability imposed on employees, and liability imposed on independent contractors. There seems to be very little difference now after the Columbia Asia case.
Okay. There are a lot of questions coming up. Maybe we will take some from Slido first.
Sure.
The top one, how does the hospital recover the judgment sum against the doctor if the hospital is hit purely because of the non-deliverable duty and has to pay the full judgment sum out first, or vice versa?
See, that is the million-dollar question at the moment, because the in the Columbia Asia case, the question of law related to the fact that the doctor was underinsured, and therefore the judgment sum was more than the sum that the doctor was insured for. And the question of law was whether the private hospital uh, is liable to the patient to pay the difference, which means the difference between the sum, the doctor's insurance, and the judgment sum. That was the question of law to the federal court. But the federal court did not specifically answer that question. All right, but the implication is that it goes further. If we look at the grounds of judgment, it appears to be that the hospital is 100% liable to the patient, which means that it's jointly and severally liable with the doctor. So how this is going to be practical? So you're right. In the event the patient makes a demand to the hospital for the full amount, it appears to be that the hospital will have to pay the full amount if it's found liable under the doctrine of non-delegable duty. And as I said, we are not sure. Previously, every time a claim is brought by a patient due to a alleged negligent act of a doctor, the hospital always takes out notice of contribution and indemnity or NCI proceedings. And in that case, what happened was after the judgment sum after the judgment is recovered, it would always be that the doctor's insurers would pay the full amount of the judgment, and usually the hospital does not have to pay anything at all. But right now, we are uncertain because the court has seemed to have stated that the hospital cannot recover under a notice of indemnity and contribution. So we do not know whether it's a general statement for the whole judgment sum or only the difference between the which is not covered by the doctor's insurers. We are not certain now.
The $6 million question below that is, will this indicate a foreseeable increase in hospital and consultants' fees?
I believe it is going to have a very wide impact in the sense that I believe that the hospitals right now, in all the new insurance policies that they are going to negotiate, will have to negotiate for a very much wider coverage, which means they are just not going to cover, the usual coverage that they've been covering. They will probably have to include all the doctors and consultants practicing in the hospital. If that's the case, I'm sure the premiums that the private hospitals are going to pay are going to dramatically increase. And if the hospitals have to pay an increased premium, I'm sure it will filter down to the patient, which is why I think that the federal court has not looked at the far-reaching implications of a judgment like this. So that's why. And to come back to your question, if that is the case, I believe the way the hospital is going, it's running for a profit, a private hospital. It will definitely the cost is going to be increased to the patient.
Ultimately, everything is going to go up if things are headed that way. It seems to be premiums will go up.
And not just that, I
running
believe
hospitals will go up. Yeah.
the hospitals may try and negotiate some kind of contribution to their premiums from the consultants. Right now you're just paying your own premium for your own insurers, but I don't know if they actually will try and make it a term that the consultants who practice at the hospital also contribute to the premiums that they are paying to their insurers. I do not know how this is going to work out.
But the last question in the Slido would be, would you agree that the take-home message would be really for doctors to have adequate indemnity cover?
I think that is a very, very pertinent question. And I think it is very, very important because if you look at the recent cases, the quantum of damages being awarded to the patients have skyrocketed in the last perhaps 2 to 3 years. I've seen a dramatic increase in the quantum being awarded to patients. So if the doctors do not take out adequate insurance, then it's going to leave the doctor exposed to the patient coming up to execute against the doctor to recover the balance of the judgment sum. There might be some protection now in that the hospitals will have to top up, but my advice is I think that it would be very wise to take out higher coverage, bearing in mind the high judgments being awarded by the courts these days.
There was a question which appeared but then disappeared because the PFSHA limits professional fees. So the doctor's professional fees, which are chargeable, are limited. On the other hand, it seems that the quantum awarded is ever increasing with no limits. And the insurance premiums of doctors keep going up, yet our fees are capped. Is this a fair situation?
I think this is something that you'll have to lobby the MMC and the medical profession will have to take it up to the legislature, because this is something when you have an act, if you feel that the act does not needs to be amended because it doesn't reflect the situation on the ground, then I think attempts must be made by the Ministry of Health, by the MMC, as well as the AG's chambers. I think a lot of stakeholders in this to try and make sure that the fees of doctors can correspondingly be increased.
There's a statement, will such a decision limit the number of private hospitals? I mean, the way it's going.
I that is not a question that I can answer.
Yeah. But what I think we have seen is this sort of situation will limit the number of doctors who are willing to take on high risk situations. Do you agree?
Definitely, I think all over the world, a similar phenomena is taking place where patients are becoming, ready to go to court, and the courts are ever increasing the amount of damages they're awarding to patients. So I believe it's going to impact the profession.
Patients may not be able to find any doctors if they are high risk to look after them.
Which is why I think we need another federal court decision where all these factors can be brought to the attention of the court. I think that this Columbia Asia decision was very legalistic and did not take into account practical matters on the ground. It didn't take into account the fact what is a doctor's obligation when they are attending to an emergency and the very short time period to respond. And a lot of, we are looking at everything with the benefit of hindsight, which I think is very unfair to the medical profession as well as to the hospitals. But that I believe is very important when the doctors are sued. Please try and get a very good expert who will highlight all these points. Because if these points are highlighted by your expert to the court, then we hope the court will take these matters into account and not find the doctor negligent. If your expert does not highlight it to the court doesn't know about this. And the lawyers are not able to say this.
I think we have overshot our time, so I'm sorry. There are a few other questions in YouTube, but we have to stop for the sake of time, and have to thank Shamini for your uh, excellent insights and fielding the questions. So we'll have to end the session, but before least, we will need to go through the last bit, which is the um, CBD points. So the dentist, you have the registration form at the top there, and you would have had pre-registered for the session. For the medical doctors, this is the attendance link, docs.my/260424. If you scan the QR code below, it will take you to that very same link, which is a Google form. And this form will be valid until 12 midnight tonight. Okay. So please, if you're watching this, you can still fill in the form. Just some, yeah, one last statement from Patrick Tan, which I feel a lot of doctors think really we should implement, is a no fault compensation system. I think sometimes things will go wrong. I think there's no, it's life, it's human nature. Things may not always go right. I mean, is a legal suit the only way forward, or should there be some other mechanism in which there is some recompense for the patient who has suffered some injury, uh, rather than go through an expensive uh, lawsuit? I think. What are your comments, Shamini? Just as a last bit one, while I put up the QR code a bit longer.
Um, you see, this thing has been on the cards for a very, very long time. But as I said, it has not got anywhere because of the difficulty in getting all the different stakeholders to agree. Because I think when you're looking at no fault, you've got very many parties involved in this system. And I think the only country that I know which successfully has implemented it is New Zealand. But as I said, there needs to be a lot of lobbying if you want to change the system or change the law. All the interested parties, in this case, I think everyone in the medical profession, which means the bodies like the MMC, then you have to have the Ministry of Health, you have to have the AG's chambers. We have to have all these people working together to formulate a new system. And then we have to put it through Parliament before it can be implemented. So it has a lot of challenges. But I think if the doctors can sit down and work out a system, then maybe you can put it forward.
Yeah. We hope there will be something, because otherwise the current situation may become quite untenable. I mean, we're talking about high risk cases. I was mentioning to you earlier about senior obstetricians who do not no longer want to do deliveries because if something happens, and it could happen after they retire, because the claims can come years later, and the premiums are so high to pay such a high in medical defense in the retirement when you're retired. It becomes really not no longer tenable. So this situation, I think it's just going to be very difficult to for practice in private sector. In the end, that a lot of high risk cases are going to end up in the government hospitals. I think that may be the situation in the near future, unless something changes. And it's not the doctors who are going to liable; it's also the hospital is going to be liable under non-delegable duty. Then, so what's going to happen? I think.
I think we have to educate the public as well on all these other problems,
Mm.
which I think the public are quite sensible. So it doesn't matter what the court says. But I think, maybe through the media, social media, mainstream media, a lot of articles about all the attendant problems which arise if doctors and private hospitals are going to be found liable and have to pay such large sums of compensation. I think we have to bring it to the attention of the Malaysian public, and then hopefully the government will do something about it. I think everywhere in the world, if you make enough noise, then people will listen to you. Right now, I think unfortunately, uh, there hasn't been enough education to the general public on what are the long-ranging implications of a decision like Columbia Asia. So I think maybe we should start there.
Yeah. Thank you very much for your comments, and I think we'll have to put this to we have to end. Although I think questions are still pouring in, but I think we have to give Shamini a rest now. So thank you very much, Shamini, for your excellent session, and I think all of us have learned about this development about non-delegable duty, and I'm sure a lot of private hospital administrators are now a bit more alert and concerned about future developments, and as well as private practitioners, we should be wary and make sure that our indemnity is sufficient for the time being. Though what is the quantum of being sufficient, I think maybe a moving target, but we'll leave this for another discussion another day. So I wish everyone here good night and have a great weekend. And I'm going to end the live stream. So remember, the link for the medical doctors to claim your CBD points will be valid until 12 midnight. Tomorrow, I will post some instructions in the comments to the YouTube video. It'll be a pinned comment to help you in case you watch this the next day or even a few days later, right up until this CBD cycle, which is the 30th of June this year. You can still claim points for watching. So I wish everybody good night and thank you for watching.
Good night, everyone. Thank you.